mission statement of the Labor Commission is to achieve safety in Utah's workplaces and fairness in employment and housing. So what we do is my division enforces the Workers' Compensation Act. And there's a lot that goes into that, but I'll explain a little bit for you. So I think you're all probably somewhat familiar with the idea of workers' compensation insurance and what it is. Just a quick summary. Workers' compensation is a special type of insurance for employers and employees that provides coverage for workplace injuries and illnesses. So if somebody gets hurt on the job, it's the work comp carrier's duty to investigate and adjust that particular claim and pay benefits if and when they're supposed to be awarded and so forth. It's separate from health insurance, has nothing to do with health insurance. And workers' compensation is actually, in the state of Utah, been around since 1917. Maybe I need to hold the button a little longer here. There we are. So it's called the grand bargain. And all that means is the employers and the employees got together once upon a time and agreed that the employees would not sue employers if they got hurt while at work in exchange for coverage and certain benefits being paid if they got hurt. So it's considered a no-fault system. So if I get hurt at work, it's not really going to be explored as to how I got hurt, but did I and what are the extent of my injuries and so forth. It's no fault. If I'm hurt, the claim is filed and benefits paid, assuming that it did happen. Now, the adjuster does have certain responsibilities and duties to explore that it did happen at work, the extent of those injuries and so forth. But a little bit of history for you on workers' compensation. We've had it here in Utah since 1917, like I said. And I didn't know this. In 2017, we had a centennial celebration of work comp, and I studied a little bit about the history. And here's your 5-minute history lesson. That work comp has actually existed all throughout history in different forms and in different cultures. The Nippur tablet, which is dated 2050 BC, outlines some of the laws of the city-state in modern-day Iraq, and it contains certain provisions related to payment to workers if they got hurt while working. The Code of Hammurabi does the same thing. It provided similar awards for injuries. And ancient Greek, Roman, Arab, and Chinese laws also provided certain kinds of benefits to be paid for injured workers. Now, the modern day father of workers' compensation insurance wasn't from America. He was actually from Germany. And maybe you know this name, Otto von Bismarck, in the late 1800s, established a workers' program to pay benefits to certain workers when they worked in coal mines and other dangerous enterprises to be paid benefits if they got hurt. Then various countries and various states within the United States started looking at more comprehensive forms of workers' compensation insurance. And it wasn't until 1911 that the state of Wisconsin passed the first comprehensive state law. Then subsequently, all the states followed suit. Utah in 1917. The last state to pass work comp comprehensive law was 1948 in the state of Mississippi. So there's your history lesson. Okay, that's all I know. If you have any questions about that, Google's a good tool. So what is it that we do? All right, so what does the Labor Commission do in our particular division? What do they handle? We've got a couple of sections here, and they handle very different, distinct things. And it's important to know about these because we may be able to assist you in some fashion. But one of our sections is the compliance section, and the compliance section's job is to ensure that all employers in the state of Utah that are required to have workers' compensation insurance, in fact, do have it. There are very few exceptions written into the law about having workers' compensation, the requirement to have it. One of the questions that we get a lot is, I've got a part-time employee, and it's grandpa, and he shovels the snow sometimes in the winter out front, and we give him a little bit. Well, technically, if grandpa gets hurt, grandpa could have a claim against your business, and yes, you are required to have coverage in those instances. There are certain exceptions for agriculture, insurance, real estate, domestic employees, and so forth, but they're viewed either as independent contractors or not employees of that employer. How do we monitor this? Well, we get a list of all the employers in the state of Utah from the Department of Workforce Services. Then when an insurance carrier writes a policy for a company, they also file that with us, and that's supposed to connect in our system, for lack of a better term. As you can see, I'm not an IT guy. Connects. If it doesn't connect, we look like we have a non-compliant employer, and we start an investigation. If they show us they have insurance, they file it, everything's good. If they don't, we proceed with the penalty process, and we then ultimately issue a penalty. Last year, we issued about 605 penalties against employers. That doesn't mean that there were only 605 employers without insurance. That's just the number we were able to keep up with. There are a lot of employers that unfortunately don't have insurance, not that they're trying to game the system, but sometimes they just don't know. There's a lot of rules and requirements when you start a business and what you're supposed to do in terms of insurance and so forth. And a lot of employers just claim ignorance that they didn't know that they had insurance or needed insurance. The penalties, we actually collect a pretty sizable amount. Last year, we collected over $2 million worth of penalties. So as you can see, the statute is pretty rigorous in terms of the amount of the penalty. It's not a slap on the wrist. It's a pretty severe penalty. The minimum penalty is $1,000, and it just goes on up from there depending on the classification of the company. The more dangerous the enterprise, the higher the penalty will be. The larger number of employees that a company has, the larger the penalty will be. So we've got 4 full-time compliance officers, and this is all they do, is investigate companies. And like I said, they really can't keep up. So we actually prioritize just based on the criteria that I just told you. We look at those kinds of businesses first, the larger ones and the more dangerous businesses. The other side of the coin is our claims section. They deal with and work with the injured workers and the adjusters and sometimes doctors. So the state does not write coverage. We don't pay workers' compensation benefits, except for one exception, which we'll talk about later. Insurance carriers write coverage. Probably 90% of the claims that we have, we never know about, which is good. We don't need to know about it. We get the claims reported to us, and I'll talk about that a little later too. But our claims section assists injured workers when and if they have a problem with their claim. They'll call us up and they'll say, hey, everything on one end to my adjuster denied my claim. What are my rights and duties? What can I do about that? All the way over to, I want to go see this doctor and they're telling me to go see that doctor. What are my rights there? Or I don't know if my benefits were paid correctly. Can you help with that? So we try to help them navigate the system. We don't advocate for injured workers. We answer their questions. We are neutral, and I need to mention that. We are neutral as is all the other divisions within the commission, neutral in everything we do. We assist employers, doctors, lawyers, injured workers, the whole gambit. But that's primarily what our claims section does. And this is an important job because if we weren't there doing that, all of these injured workers that contact us, and last year I looked the number up right before I came in today. We had 2,009 injured workers contact us last year. And if we weren't doing that job, we probably have about 2,000 more applications for hearing filed with our adjudication division, and that would overload them. A lot of these questions are easily answered. We explain the rule to them, we explain the statute. Sometimes we'll call the adjuster and they'll give us some more background information, and we'll explain it to the injured worker. And that's very helpful. So a few facts: injured workers have 180 days to report a claim. The employer has 7 days to file that claim with the insurance company. The insurance company has 14 days to file that claim with us. Now, it doesn't mean it needs to be an accepted claim or even a denied claim. It's just that we've been made aware that there is a claim. So that's where we get, I think I'd mentioned we had about 60,000 plus claims filed last year. And we just get the report of claims. So we're sort of the compositor of all those claims. And then the subsequent filings that go along with those claims, what happens? The insurance carrier has a little bit more time to investigate that claims, 21 days. Then they can accept or deny it. If it's accepted, and then there's more filings that happen with us. And we sort of collect all of that information. But that's what our claim staff does. It helps keep things timely. A lot of times we'll get questions from injured workers that says, I told my boss I was hurt, I've got no idea what's going on with my claim. I hadn't heard anything for 2 weeks. I missed a couple days worth of work. Maybe they went to their doctor. Maybe they didn't go to their doctor. We can look up in our system and see if the claim is in fact filed. We can see who the adjuster is and the insurance carrier, and we'll call them and find out what's going on. If it's not, if it is filed, we'll let the injured worker know that, let them know where the process is. Sometimes they're a little eager to get things moving, but there's a certain time frame allowed for adjusters. So those are the kinds of questions that our claims section answers. And we will allow a little bit of time at the end for questions if anybody has any. I know I'm kind of moving through it, but I want to make sure I cover everything. The other section that kind of works behind the scenes and is the motor that keeps the car running is our quality and support team. They ensure that all reported claims and insurance data is timely and accurately reported. So all those 60,000 injury claims that I just talked about, they are the ones that receive that information, get it into our system, and then our claim staff can pull it up and see what's been reported. Now, that doesn't mean that there are 60,000 individual documents filed. There's hundreds and hundreds of thousands of documents filed, and it's all done electronically now. When I first started at the Labor Commission, everything was done manually. It was all manual data entry. We had probably 60 to 80 hours worth of data entry that our claim staff did instead of assisting injured workers, just to get all that stuff into the system. Now everything's done electronically. It's a great system, and at the hit of a button, we can pull up an injured worker's claim and see what all's been filed, see what's going on with it. A couple other things our quality and support team does. One of them is a collections manager. So all those penalties I was talking about before, they assist us in getting those penalties paid. If the penalties are not paid, it goes upstairs to the AG's office, to our collection attorney. We have a full-time collection attorney that works just for us. Jason mentioned that I'm an attorney by trade, but it's kind of nice being the client on this end of it. I tell him what we need done, and he does it and gets to appear in court and all those other fun things. And but we have a collection manager that kind of oversees the collection of those penalties and so forth. And we have another individual in our quality and support team that is our self-insured coordinator. Now that means something to all of you, because the Utah Local Governments Trust is a self-insured entity in the state of Utah. Now, what is that? What does that mean? It just means that the statute allows for certain large employers in the state of Utah to do what's called self-insurance. It means they don't have to go out and buy a separate policy for insurance. They can manage and adjust those claims in-house. They have to be a large company. For instance, we have everybody from Wendy's restaurant to Kennecott to the church. All are self-insured entities. We have about 40, 42, I think last time I checked. Some nationwide companies, some Utah companies, and they're required to have a certain retention amount, money sort of set aside to pay those claims, security. Jeff knows all about that. I've talked to Jeff a number of times over the years in his different roles about security and those sorts of things. And so it's kind of interesting dealing with the self-insured entities. But Utah Local Governments Trust is one of our best partners. We have the fewest complaints probably about your organization. I was bragging to Jason a little bit earlier. And you're great partners with all the different individual entities that you've got that are part of the trust, and the work that you do to address injuries when they occur and to handle them is hats off to all of you, and I appreciate that. So if there's ever any questions from anybody regarding a claim and what happens for a city or a county or anybody else that's part of the trust, you can call our office. Our self-insured coordinator will help out with that, and our claim staff helps out with that as well. Okay, moving along. Moving along slowly. There we go. Okay. So Jason mentioned that as part of my role, I'm also the administrator of 2 individual funds. This is just interesting information for you. The first one is the Uninsured Employers Fund. And what this fund does is it covers claims. And you step a little closer. There we are. It covers claims for injured workers who were injured working for an employer that did not have work comp insurance. Now that's a whole separate process. So you've got an employer that doesn't have work comp insurance. They have an employee that gets hurt. Now what happens? Our statute says that that employer is to pay first dollar on that claim. They may not always do that. They may deny the claim. They may not want to pay. They may not have the money to pay. So what happens? Well, unfortunately, the injured worker has to file an application for hearing in that scenario. The uninsured employers fund is named as a defendant, a co-defendant with the employer. We have another attorney from the AG's office that represents this fund and handles and reviews all of these kinds of claims. Like I said, the employer may be involved, they may not be involved. If they are involved, we make them pay first dollar. If they're not involved, then the money will come out of the fund, and then we have subrogation rights against the employer, and we can go back and try to get some money from the employer. A lot of employers are very cooperative. We'll make payment arrangements with them where if it's a large claim, $10,000, $15,000, $20,000 or more, we'll pay the money, and then the employer will have a payment arrangement to pay the state back. Another interesting thing is, an obvious question is, well, where does the fund get its money? Remember all those penalties I was telling you about? They go right here into this fund. We also get money from a certain premium tax that's assessed on all workers' compensation policies that are written in the state of Utah. 0.5% of the premium also goes into this fund. So all of our stakeholders together are very interested in making sure that everybody has workers' compensation insurance, because for those that don't, and if this fund gets assessed a higher rate, it impacts everybody that's playing by the book, playing the rules correctly. So we want to make sure we're doing our job to keep our stakeholders happy and make sure that everything is moving along smoothly. We probably have anywhere from 40 to 60 open claims at any given time with the fund. But it's a very beneficial fund. Most states have something like this to help pay for injured workers that are working for an employer that does not have benefits. And this fund was set up in 1984. The other fund that we have is the employer's reinsurance fund. And this is kind of a unique, kind of a weird fund to try to explain. This fund was actually set up way back when work comp was established in the state of Utah, and it was originally called the Second Injury Fund. So back to our history lesson, back in the 1800s in the United States, before there was work comp, what happened? What happened to an injured worker? They got hurt on the job. Well, they had the option to try to sue their employer if they wanted. By and large, they weren't very successful. They were hurt. Maybe they couldn't work at another job, or at least a similar job that they had been doing. And what started to happen was the courts looked favorably on the employers. They didn't award a lot of benefits when there were claims filed, so people just didn't file claims. Well, then there were a couple of large cases in the late 1800s, early 1900s that sort of flipped it the other way, and employees started getting larger awards. And then that's what brought the employers to the table, and that's when the grand bargain was sort of formulated, and then we've got our current work comp system. But back then, you still had a number of employees that got hurt, tried to find another job, and then the employer saw them sort of as damaged goods, if you will. Maybe they could or couldn't do their job. So this fund was set up to pay, to encourage an employer to hire these injured workers. And then if they got hurt again on the job, or a subsequent injury or an aggravated injury, this fund stepped into play to pay. So it encouraged employers to hire injured workers from other jobs and so forth. So now this fund is sort of transformed into a permanently and totally disabled fund, where the only individuals that get paid out of this fund as of 1994, when it was legislatively set to sunset, are permanently and totally disabled individuals. When I started the commission, we had about 1,300 of those individuals. If their injury happened prior to 1994 and they were totally disabled, they were put on the rolls of this fund and they received lifetime benefits. Now we're down to, I think, 500 to 600 individuals that are on this fund. So when the last person passes away, this fund goes away, and there's really no purpose for it anymore. Now, if somebody's permanently and totally disabled today, what happens to them? And if their employer doesn't have insurance, what happens to them? Well, they get put on the rolls of the uninsured employers fund. So that fund's kind of taken over and replaced the employer's reinsurance fund. Okay. Last thing I'm going to talk about, there's a couple other miscellaneous things that our division does to assist the public, and we call them stakeholders, the attorneys, the adjusters, insurance carriers, and so forth. The first one is we have a medical director. We've got a new medical director now. Our old retired medical director was with us for 27 years. He was the first medical director we ever had. He just retired. His name was Dr. Alan College. You probably have heard his name around. We've got a new medical director now, Dr. Douglas Shepard. He just took over last month. And what the medical director does is he assists with questions, training, bill review questions, things like that. So if an adjuster has a question about how to do an impairment rating, or a doctor's doing an impairment rating, is it right or not, our medical director will help explain our laws and rules. Also, we get a lot of questions about billing, a lot of them. For medical providers that think the carrier hasn't paid right, or from the carrier that thinks the medical provider is billing wrong, and then there's a dispute, our medical director helps answer and sort of wade through some of those questions and tries to provide the best answers possible. And then the medical director does a lot of training for doctors, primarily. How to assist an injured worker with an injury. Dr. College used to like to call it, it was red tape. The hassle factor is what he called it. So to see an injured worker, it requires a lot more work than a normal general practice physician to see somebody in the health area, because you have a lot more paperwork you have to do. So the medical director assists in training and making sure that we have enough doctors in the system that are willing to see injured workers. And that's something we really want to keep an eye on. And it's a question that's come up over the years. Do we have enough doctors? Dr. College said that when he retired from his practice, he didn't have any doctors or physicians in his group that wanted to take on work comp. He was it. So we're cautious in watching and making sure there's enough medical care to go around for injured workers. Another thing that we do is we provide something that's called a workers' compensation coverage waiver. I told you earlier that there are very few exceptions to an employer not having to have workers' compensation insurance. So Utah law allows, and this is very rare, there are almost no other states that do this, but Utah law allows an individual who has no employees but who hires out their services to another person. The best example is a subcontractor to a general contractor. They can get what's called a work comp coverage waiver. What that means is they've opted out of the system, so to speak. The employer who's hiring that subcontractor is safe from any penalties or from any claims of injury if that individual got this waiver. The individual that gets this waiver has to have no employees of their own. They have to be a sort of a sole practitioner, if you will. I mean, you can be a partner with somebody else, that's fine, but they have to have no employees. The reason this is important in Utah is because we do have a statute that says a general is a statutory employer of anybody that they hire underneath them. So you have a contractor, a subcontractor, and sometimes those subs hire people, and then somebody way down here gets hurt, and it rolls all the way up. And now who's responsible for that claim? So a statutory employer will say, well, wait, I didn't hire all of these people. I just hired a contractor. I don't care who the contractor brings to the job. Well, so Utah came up with this waiver thing that says, well, those individuals, if they really truly are independent contractors and they don't have anybody working for them, they can opt out of the system, and so that general is safe. That's sort of known as a safe harbor for the employer in that instance. So we issue those. Now, this is just kind of an interesting fact. When we took this over in the mid-teens, 2014, I think it was, the Workers' Compensation Fund used to issue these. And they felt it was more appropriate for the state to handle it, and we agreed, so we took it on. We probably had about 6,500 applications for individuals trying to get these waivers, and it increased every year. And it's doubled in the past 10 years, and it's been shooting up in the last 3 years. We've had about 14,000 applications. We issue about 10,000 a year. And we've got a lot of independent contractors in the state of Utah. I think it's a testament to our economy, how it's been growing over the past number of years, businesses moving here and so forth. So we're trying to keep up with that. All right, I've spent way too much time on waivers. Another thing that our division does is, well, what I'm doing here today. We offer training. We've got our claims manager that mostly does the training for the division because most of the requests for training come from adjusters and insurance carriers. So we're in the process of putting some training materials online for everybody to answer the most basic questions. And then if you'd like to speak to a live person or do some virtual training or in-person training, she'd be available to do that. But we also have employer groups that occasionally contact us to do training. And then I have our compliance manager do that because he works with the employers. And if we have doctors that need training, then our medical director will reach out. So if anybody needs training really on anything work comp related, that's part of our purpose and what we want to do. I already mentioned collections. I don't need to get back into that too much. Last slide, and I just want to remind people on behalf of us and on behalf of OSHA, Utah Occupational Safety and Health Division, to work safe out there. Please work safe. It was kind of funny. I took this picture from a prior presentation I did a number of years ago, and I was Googling unsafe work practices and pictures. There are hundreds of pictures like this. I couldn't believe it. I could fill up the next 20 minutes of just slide after slide after slide of people doing creative things like this. I don't know what the outcome was of this. I hope everybody was safe, but you'd be surprised at the kinds of injuries we hear about. A lot of them are just standard injuries, of course, slip and falls and things like that. But we get a lot of claims where people were fighting in the workplace, for instance, and somebody got hurt. Well, now is that a work comp claim? Were they on the clock? Was it in the course and scope of their employment? I mean, there's the questions that adjusters have to answer, but we get all kinds of very, very strange claims. So anyway, just a reminder to please work safe out there, okay? I don't have anything else. That concludes my presentation, but I'm happy to take questions if anybody in the room or if anybody online has any questions. I'll see
folks, if you got your questions, if you're online, type those into the chat box. And here in the room, we're going to pass a microphone around so the people online can hear.
Could you talk a little bit about how short-term disability works in conjunction with an injured employee's workers' compensation? I know they're only compensated up to, is it 60%? And then I'll just let you talk.
Yeah, we don't get a lot of, so short-term, you're referring it to a short-term disability, but we look at it, we have 4 different injury types that are written into the statute. Temporary total, which means I can't work at all, but I'm totally disabled, but only for a temporary time. Perm partial, let's see, temporary total, and there's a couple other, I'm drawing a blank at the moment. So if an injured worker can't work for a certain amount of time at all, then the question comes up, well, do they also perhaps get disability benefits? The system is primarily designed to not let an injured worker get 2 bites of the apple. That's sort of the phrase that's used. There are disability benefits that could be payable to an injured worker, but it kind of depends on the situation. I hate to sort of revert back to that as sort of a fail-safe, but it kind of depends on the situation of the injured worker. Disability benefits may be available depending on the length of time they're out and what's going on with that work comp claim and the type of injury that occurred. That may not have specifically answered your question, but I'm happy to follow up with more information and reference you to the statutory portion of that. But a temporary injury that's total is only up to a certain amount of time. Then it could move into a perm total situation. So, you know, it all depends on the kind of injury, and then that'll fit it into the particular kind of statute.
I think it depends on how your short-term disability policy is written. Generally, they won't pay short-term while they're currently on workers' compensation.
Right. It's not a supplement.
Yeah. It's not that type of, usually it's not that type of insurance on short-term disability.
We don't get a lot of short-term disability questions because we're just dealing with the work comp piece of it and questions from the adjusters on whether they're paying the right amount for work comp. Then if they've got a question on short term, I mean, obviously they're going to have to deal with the employer on that piece of it.
So my question is, if you're the entity, for example, and you're hiring a contractor to put on a new roof, and so they have to peel back the old roof, then they're installing the new roof, They then hire a subcontractor who has a waiver to clean up the material around the building. That guy gets injured. Does it come back to the entity?
It should not.
How
In-
does the entity prevent that from happening?
So what happens is, what we tell the hiring entity to do is, anybody that you're hiring as an independent contractor, you either need to A, have insurance on them, or B, get a copy of that waiver. Because that's your safe harbor, and if they get hurt and file a claim, they can file a claim. That's your number one piece of evidence for defense.
Then a follow-up, how do we as the entity know if that person is an independent sub from your original contractor?
Ask.
Ask.
What I would do is, that hiring entity is anybody that's working directly for me, I'm gonna have a waiver on them. They can't get the waiver if they have employees themselves, because that's kind of how the waiver works. I mean, if somebody gives me a waiver, I'm gonna know in theory that they don't have contractors working, or I'm sorry, employees working for them. Now, they can have a contractor work for them too, and then they should get a waiver from that person. And you could go several levels down. But if any of them has employees, we don't give them a waiver. They have to come in and show certain evidences that they are a truly independent contractor, no employees. They're licensed to do business in the state of Utah as a business under a certain business entity and name. There's a whole criteria in the statute that we go through when they file an application for a waiver. We don't just write a waiver just because somebody asks. So if an entity gets a waiver from an individual, they can be pretty assured that that individual doesn't have employees that could get injured. And assuming they don't have employees, if that person gets hurt, that's the employer's safe harbor to defend against a claim. So we can get some pretty complicated scenarios of people coming in asking for waivers. And a lot of subs will hire people or family members or what have you, and just say, well, they're not really my employees, they're just independents as well. You know, I hired a buddy around, lived on my block to do some work for him. Well, did you get a waiver from him? I mean, I know it's a little bit of extra work and they don't think to do that, but if the employer or the hiring entity up here at least has one from this person, that should be where it stops. And we have a lot of situations with the uninsured employers fund where you have that scenario where there's several layers, individuals, and then somebody down here gets hurt. Maybe there's a waiver up here somewhere, but the person down here hiring doesn't have any money and they can't pay a claim. They're just a buddy, and then they just go out of business or what have you. So the uninsured employers fund has to step in and pay a claim. I think that's a very wordy answer to your question. So.
I'll just address that question quickly as well. And this all begins at the contracting process, certainly not at the claim process. So anytime your entities bring somebody on, you need to, in your protocols and through vetted through your attorneys, have within your documentation that the contractors will have this insurance, and that the contractors will ensure that their contractors have it. And then you have that safe harbor, but it happens way before you bring it on. It should be a standard practice, completely vetted through your city attorney or entity attorney. So Ron, you're talking to a group of public entities. They're insured through the trust. So they've got workers' comp. We won't have to worry about them being uninsured. But what would you say would be the best advice, or based upon the trouble calls you get at the Labor Commission for employers, what can we do to make sure that we don't get in trouble with our workers' comp claims based upon the phone calls that your people receive?
I guess it depends on the kind of trouble you envision maybe happening. I think with the Utah Local Governments Trust, like I said, very, very few issues we've had from the self-insured claim side. Now, we assist with answering questions. So if you get somebody from a particular city or district that has an injury and they're not sure what's going on, they'll come to us. So what we like to do is make sure you all adequately report the claim and answer questions as best you can. If they come to us, we're going to try to have them answer questions for them. We don't want to tell them, and this is a last resort that happens, if the questions aren't answered and we can't maybe get a hold of an adjuster or risk manager or somebody to help us answer the question, and that injured worker is desperate in that moment, we'll tell them, look, your option now is to file an application for a hearing. Well, now it goes down a whole nother road, and we don't really want to go down that road. So, I hate to sound like a cliche, but education and communication are probably the two biggest things to make sure your workers know what's going on if there is a claim, help them through the process. If you have a doctor that they're supposed to go see, make sure they know who that is. I mean, that helps us, but that helps us help you, I guess. Do you have any specific scenarios, Jeff, you're thinking of in terms of trouble or issues? I mean, I'm thinking on the claim side, because obviously the policy side, you guys are fine.
Right. No, that's what I was thinking is, communication definitely helps out. Make sure your employees know who in your organization to come and talk to if they have a question. And of course, you can always call me if any questions come up with you in your organizations, and I'm happy to help you. I would like to just interject here that, I love the workers' compensation system. Now, I'm an insurance guy, so I'm geeky anyway, but and I have to wonder why Ron, as a reformed attorney, stays with workers' comp all this time, but he's probably like me. Um, but the great thing about the workers' compensation system is it's statutory. There's no gray area as to what's covered, what's not covered. And so any questions that come up, they're easily answered in almost every case. And so if you don't know the answer, call the adjuster, call me. We'd be happy to answer that question for you. And that resolves so many problems. Employees wonder, well, the doctor's bringing me back to work. What does that mean for me? They wonder about where they can get treatment in the first place. That's up to you to be able to let them know that. And if you don't know exactly what to do when an injury comes up in your organization, let me know. I'd be happy to walk you through it and help guide you to resources that we have online to find clinics and all of those sorts of things. I would also just like to point out too how good Ron's division is doing and how good the laws are in the state of Utah. How many of you have driven through Las Vegas or California and you see posters for attorneys that represent just workers' compensation employees? There are states where the system is so bad that we in Utah here say, what we're going to do here is what they don't do in that state, right? Utah, our premium rates are like the lowest in the lowest category of the country. I think we're at number 45, so maybe 5 states that are less expensive in premiums than Utah. And that's because in a lot of ways we have good medical care here, but we also have a good workers' compensation law and system so that employees get what they need, as opposed to hiring attorneys for every claim that comes along. So we've got a great system here. Don't hire people out of state if you can avoid it, because you might pay a lot more for those claims. But the Labor Commission does a great job. Ron's division leads that charge.
Jeff, I don't know if you introduced yourself. Would you just?
Oh, sorry.
for the people that aren't-
Yeah, this is Jeff Rowley, claims manager at the trust. Sure. So I'll come up here so that I'm on camera here, share the spotlight with Ron. We've got the same jacket
good.
pretty much.
Yeah, we look good, Jeff. Don't we? I told Jason earlier, Jeff could really give this talk if I wasn't available, because I've known Jeff for years and years, and he knows as much about the work comp system as I do. So
I still call him with questions. So workers' compensation, we start with the fact that it is primary. If your employee is injured on the job, whatever workers' compensation pays, others don't pay, because it's the first place to go for your injured workers. If they're hurt in an auto accident, there may be other coverages there, but workers' comp pays first, and statutorily, generally, auto insurance won't pay. Same with short-term disability. It's generally not meant to cover that, because short-term disability often only pays the same amount that workers' compensation pays. And so that portion of what the employee's lost is already covered under workers' compensation. When an employee is taken off of work, workers' compensation pays up to 66 2/3 of their pre-injury wage for the full time that they are taken off work completely. That's temporary total disability. They may be able to be brought back to work part-time, and then workers' comp pays 2/3 of the hours that they miss under temporary partial disability. We encourage you as employers to have good return to work programs. Now, what's a good return to work program? Number one, leadership from top down welcomes employees and wants to bring them back to work so that they can be productive. Employees that stay off work for a long period of time, they lose contact with work. they lose their momentum. They don't feel like they belong, especially when nobody in the workplace is communicating just to say hi and how are things going. So bringing them back to work actually helps the employees. But that starts at the top level. If you don't want to take the time, well, you'll pay the price for not bringing them back. There is a direct and there are indirect costs for not bringing employees back. But you want them. You want to bring them back, and you encourage that before the injury. We will accommodate your injuries. When they come back to work, workers' compensation stops, and you can pay their wage, and you're allowed to pay them their pre-injury wage, even if they are doing less than their normal job. And you should not bring them back to do more than what they medically are cleared to do. Also, while an employee is off of work and workers' comp is paying 66 2/3%, that's untaxed. That is not the same percentage of their paycheck as you might think it is. It's untaxed. So it comes up to 85% of their pre-injury wage. Some employers will say, gosh, I feel bad they got hurt. I want to make up the difference. Not a good idea. If an employee is getting paid 2/3 without getting any tax, and then you add on some free money on top of that, and not to say you shouldn't help them, let them supplement it with their leave available, their sick leave or their vacation, depending on your policies. But if you just pay that additional amount, the employee's sitting back going, I just got the dream job. I can stay home. I get paid what I got paid before. And in some cases, I get paid more because the employer is reimbursing them 1/3 where they're already getting more like 80%. And so adding to that just incentivizes employees to stay unwell and stay home. As Ron mentioned, the workers' compensation is designed as a compromise between the employer and the employer. Both parties have skin in the game. And if you don't give them skin in the game when they're off work, what's their incentive? They kind of lose that. So I hope that answers your question on short-term disability. It can sometimes turn into long-term disability too, when sometimes an employee's injury is bad enough that we get to a point where medicine has done all they can do, and the employee is at what's called maximum medical improvement, and yet they still can't come back to work and do the job they had before. That's when your disability policies may kick in and provide additional benefits on top of that. But at that point in time, workers' compensation is done because they're medically as good as they can get. Do you have anything to add to that, Ron?
No, actually, I'm glad you hit on the 66 2/3. I
Oh, you
don't
don't
need
need
that. Because we get that question a lot. Well, how did the legislators come up with that amount? Well, it's for that reason. It's not taxable. So they kind of just did some rough math and said, well, you get to keep it. You don't have to pay tax on it. It's close to what you should have gotten. We also, before your injury, we also do get a lot of questions from employers on what Jeff just mentioned. Well, my employee's not getting paid enough on that I don't call it disability, but on that temporary total benefit. Can I pay them extra? Is there anything that prevents me from doing that? Well, the short answer is no. You can do what you want, but as Jeff alluded to, the incentive is to get them back to work. That's what keeps the premiums down. And from the medical side, Dr. College talks about this all the time, the health of the worker population, to be productive, to be working. What the mental and physical health benefit is to that is enormous, as opposed to somebody staying home, getting depressed, they're isolated, maybe they're getting money for being home, and it just sort of snowballs. And then they start having other issues. So anyway, yeah, Jeff hit on some great points. I'm glad he did.
Thank you, Ron.
Do we have any other questions in the room? We have a couple of questions. One of which is do you communicate with UOSH, with Utah OSHA? So if somebody you see a lot of claims or high severity claims, is there any communication between the divisions?
No, that's a great question. Actually, there is, although we have very distinct mandates, we do talk because they go out and do investigations on dangerous work environments. And if they're made aware of an injury, they'll notify us. And then we'll take that information and see if it's properly been reported to us or not. The communication mostly goes this way, but we are sort of the warehouse of all the employers in the state of Utah. My division is. So OSHA will get information on the employers and how many employees they have and so forth in order to do their investigations. We also get information on deaths. We have a certain number of deaths each year, and then UOSH collects that information for the federal government. And then we're also aware of that as well, if we need to do any investigation. And usually our investigation involves penalties on the company for not having insurance. Ours is on the insurance side, UWash's is on the safety side. So yeah, they can kind of get hit from multiple sides if they're not playing above board.
Okay. Another question. Can you pay for your own claims? Let's say you have workers' compensation coverage. I've had questions like this in the past. You know, we had an employee got a puncture wound and he needs a tetanus shot. Can we just pay for that and not do a claim?
The short answer to that is a resounding no. You can't do that, except the law does provide for certain kinds of injuries that fall within the definition of what's considered first aid. Dr. College would always like to say if an employee gets hurt and it's something a Boy Scout can help you with, then that's considered first aid and you're okay. However, we do have employers that try to take care of claims on their own because they don't want that reported. And we actually have a statute that says we can issue a penalty against that employer for paying that claim. So if the employer gets caught paying a claim, they're going to get hit with a double whammy. So the answer is no, but yeah, very minor injuries don't need to be reported. If it's something that you can kind of take care of in-house, you get something in your eye and you have to clean it, or bandages or small scratches and things like that. The Work Comp Act looks at it that if you send them to a physician and the physician bills for the service, then that's a reportable claim. That makes it reportable to us. And they need to bill the insurance carrier, and it gets a little sticky on some of those very small claims. But if anybody has any questions on a specific incidents, please give us a call and we'll kind of help walk you through it.
Okay. We had one other question regarding, let's see, it says recently we hired a group of cleaners, 3 to be specific, who ran a cleaning company. We hired them and had them get a waiver. Did we do the right thing?
If it depends, they can get a waiver if the 3 individuals that came in to apply for the waiver were all partners. If one was a boss and the other were employees, or if it was a company with employees, then they wouldn't have been given a waiver. So the fact that if they did get a waiver, then they met the criteria and they would have been fine. And if that's the case, then yes, you did do the right thing, because if one of them would have got hurt, they might have been able to file a legitimate claim against you as their statutory employer. But it all depends on, cleaning for an office building versus cleaning at home. I mean, there's different scenarios. But if they got that waiver, then they can hire out their services to anybody, and whoever hires them is sort of safe from any claims, or should be.
And I was running a little bit, but I had one quick question on posting for workers' compensation coverage. Did you talk about that? Did I miss it?
Oh, no, I don't think I did. Posting, what do you mean? In what way?
Posting up the poster that shows that you have coverage.
Oh, yeah. We don't deal with that a whole lot, but yeah, there is a rule that says the employer is to post information on who their carrier is, and if you have a preferred provider, and that's a whole nother discussion we can have someday. A certain provider or a group that you want your injured workers to go see, that should be posted as well. Because a lot of times it's sort of a semi-emergency situation. Somebody gets hurt at work, the boss isn't there, maybe there's just a manager there, or maybe the manager's not there. You have to have that poster up so they know where to go and who to contact.
Yeah, and we highly recommend that our members do that as well. So they one know that the trust is covering that, but as well directing care. That's one of those great things about being in Utah, is that you can direct care, and we can go to our clinic that we know is an industrial clinic. They know how to work within the workers' compensation system, and sometimes a primary care provider has never dealt with that, and they don't know what the statutes are and exactly how to deal with that. And we may end up with people taken off work that don't need to be off work, and that ends up bad for the employee and bad for us as well, and bad for the premiums in the long run. So.
Thank you, Jason. And I just wanted to also thank you, Ron, for your great partnership and for all the work you do. I wanted to just underscore one point, and that is when workers' compensation claims happen in your organizations, take control of those claims. Don't just let them float out there. If you've got somebody who's off work, find out what happened. Make sure that you have policies internally that require employees who go off on workers' compensation to bring back work restrictions to you so that you can control what's going on. That's the most important thing. We see a lot of times where employers don't take advantage of that communication that Jeff was talking about, communicating with the employee, letting them know, hey, we do have return to work programs, letting the doctors know if you have a clinic in your area that you use regularly, as Ron's mentioning, that we can direct care, be sure that you communicate with them. Let them know, hey, this is our organization. We accommodate light duty. Make sure that all of our people that are sent out to you come home with a light duty restriction. And then that way, you can decide what you can accommodate and not. But that's the way to really control this. Sometimes we'll see these, people taking off work, and it just goes on and on and on. And when we look into these, the employer hasn't made the contact that could have been made right up front. And the adjuster, of course, keep in mind, the adjuster is going to work with the employer to help you with that. But the reality is that they're your employees. And so the adjuster is usually finding things out later than you would internally. So just take advantage of that.
Yeah, and I'll add to that the biggest complaint we have are just angry, unsettled workers who just don't have information. Maybe they're not having their phone calls returned, and I get it. Adjusters are overwhelmingly busy, but if you can do your best to help them out, it's going to save you a lot of heartburn in the long run.
Sure. One more.
This is Jill. I'm one of the member services departments here. And back to the notice to post, I send those out quite regularly. But if you need some, just email me and let me know. It's my understanding you should have that notice to post in each building where employees are. And if you need updated versions or anything, just email me, jill@utahtrust.gov. I'm happy to get those to you.
Excellent. Thank you, Jill. Appreciate that.
All right. Any final words?
I don't think so. I think we covered a lot. The only other thing I'll mention is if any of you walk away today and think of a question, please reach out to us. That's why we're here. Whether it's a claims question, an employer question, or something within the law rules, or a treatment issue or something like that, please reach out to us. We make ourselves available every day, and we've got a great staff that works with us. We're actually one of the smallest work comp programs in the nation. I think Rhode Island is smaller than us. But we're very small, but we're very efficient. Like Jeff said, I mean, we don't tinker with the engine because it's running pretty smooth right now. But we're here to help. So with that.
But I want to highlight the fact that we've talked a lot about administrative processes here. Take advantage of the Trust Loss Prevention Team. Okay, we will help you develop programs and design programs that will reduce injury. And so make sure you use our experts. You've got Jason, you've got Mike, and these people know what they're doing. They can help you identify things that can be put into place simply and quickly. We've got team appreciation and recognition programs that will help you accomplish your goals and your objectives around loss prevention and control. And thank you for your partnership.
Let's give Ron a big round of applause.